Hello everyone, welcome to Drishti IAS. You're watching the Revision with MCQ series, and today we are going to be covering the subject of polity with the help of practice MCQs. So without further ado, let's plunge right in and begin with the first question. Consider the following statements regarding Article 20 of the Indian Constitution. Now, before we look at statements that have been given to us in the question, let's first discuss what Article 20 is all about. So Article 20 provides protection in respect of conviction for offences. So we are talking about certain protections that are provided to citizens in respect of conviction for offences. Now, when we are talking about offences, we are over here talking about serious offences, that is criminal offences, criminal matter. And what are the protections that are provided to the citizens, that are afforded to the citizens? Those are Article 20, Clause 1, no ex post facto law, meaning you cannot punish someone for a crime that he committed or an action that he committed, which at that particular point of time or in the past was not a crime. So maybe today you legislate and make an action a crime, but at the time that a person committed the action, if it was not a crime back then you cannot be punishing the person for the same. The second protection is no double jeopardy. What do we understand by jeopardy or double jeopardy? We mean that you cannot punish someone, you cannot prosecute and convict someone for the same offense twice. That is the concept, and that is also a protection against conviction that has been provided to citizens by our constitution. And the third one is no self-incrimination, meaning that you cannot force someone to testify against themselves either in an oral form or in a documentary. So you cannot really push someone to provide oral or documentary evidence against themselves. However, this does not apply to certain cases. So for example, the courts may order to provide the samples of signature or blood samples or fingerprints. All right. So there it does not apply, and it only applies to written and oral evidence. Now, these are protections against or protections in criminal matters, as we have discussed here, for criminal offences, and do not apply for civil or administrative matters. So with this background in mind, let's try and attempt question. Statement 1 says the protection against self-incrimination applies only to criminal proceedings and not to civil or non-criminal proceedings. This is accurate. The second statement says the protection against double jeopardy is available in proceedings before departmental or administrative authorities. This we just discussed is inaccurate, and both the protections are available only in criminal matters. So here we only have the first statement is correct, and therefore option A is our correct answer. This is the explanation. Kindly pause and read it for more details. Question 2 says, consider the following statements regarding the evolution of Article 21. So here are discussing the evolution of Article 21. Now, what is Article 21? Article 21 deals with protection of life and personal liberty. So, another fundamental right which deals with protection of life and personal liberty. Now, here two statements are given, and we are talking about the evolution, as in how has the interpretation of this article evolved with time. So the first statement says, in the Gopalan case of 1950, the Supreme Court held that Article 21 protects against arbitrary legislative action but not arbitrary executive action. Now, when we talk about this article, when we talk about Article 21, it simply said that no person shall be deprived of their life or liberty except by law. Except by law, or rather, except by procedure established by law. So, if there is a law that sanctions taking away of life or liberty by the state, then this article, in its earlier evaluation or its earlier interpretation of the A.K. Gopalan case that we are just talking about, then that action would be justified. No concern was given for whether law was fair or not. So fairness of the law was not even a question. If there is a law and it authorizes the state to take away life or liberty, then that action was justified and the fundamental right under Article 21 was not violated. So it was not protecting against either arbitrary laws or against arbitrary implementation. However, in the Maneka Gandhi case, the Supreme Court decided and came up with a new interpretation, which was a broader interpretation. In the Maneka Gandhi case, the Supreme Court came up with a broader interpretation. The earlier one was a narrower view. So in this, the Supreme Court said that the law, such a law which deprives a citizen or an individual of their life and liberty, should be fair, just, and reasonable, should be grounded in reason. So then it provided protection against arbitrary legislation, meaning, or legislative action, meaning the law should not be arbitrary, it should be grounded in reason, it should be fair, should be just. Also against executive action, arbitrary executive action, meaning that it cannot be simply implemented without considering its reasonableness. So with this background in mind, let's understand. In the Gopalan case, 1950, the Supreme Court held that Article 21 protects against arbitrary legislative action but not arbitrary executive action. This statement is incorrect. In this particular case, Supreme Court provided no protection whatsoever or did not interpret Article 21 as providing any such protection whatsoever. There was only the procedure established by law, and if that law, if the procedure was meeting with the standards set by the law, the action was justified, the state action was justified. And there was no protection either against arbitrary legislative action, meaning whether the law was unreasonable, or against arbitrary executive action, meaning the law was reasonably implemented or not. In the Maneka Gandhi case, the Supreme Court extended Article 21 protection against both legislative as well as executive arbitrariness. This is absolutely accurate. So we arrive at the correct answer, which is option D only. Now here we can look at the explanation that is given. So from procedure established by law, which was the narrow view earlier, the stronger American expression of due process of law was adopted. And here, as we can see, unless the procedure prescribed by law is fair, just, and reasonable. So this due process of law was actually kind of considered. Patch. So here in the explanation, you can see that in the earlier interpretation, the Supreme Court's interpretation was actually inspired by the procedure established by law, which was distinct from the American expression of due process of law. But later on, the Supreme Court held that no person can be deprived of life and liberty unless the procedure presented by law is fair, just, and reasonable. So the test of reasonableness has to be there. Question 3, consider the following statements regarding the Supreme Court judgment on the right to privacy. Now we have the right to privacy, and right off the bat, we understand that right to privacy 2017 case was the Justice Puttaswamy case of 2017. And what did this case say? It actually made right to privacy as a part of our fundamental rights under Article 21, which is, we just read about it, right to life and personal liberty. Now, the first statement says the judgment identified bodily privacy, informational privacy, and privacy of choice as core components of the fundamental right to privacy. Now, when we talk about bodily privacy, we are talking about any sort of bodily decisions of the person. Bodily autonomy is granted to the person. So, this indeed is a core element of the right to privacy. The second one talks about informational privacy. Here, we are talking about personal data. Personal data. And from personal data, you can infer that this right is simply not only applicable to the state or against the state, or the person has that right not only against the state but also against corporations and individual entities. So against other citizens, other people, as well as against other private entities like companies and corporations. From this very term, you should understand. And privacy of choice. When we are talking about privacy of choice, we are talking about personal matters like marriage, like my food habits. All of this do form the core components of the fundamental right to privacy. Therefore, the statement is correct. The second statement says the Supreme Court unanimously upheld the earlier rulings in MP Sharma and Khadak Singh as correctly interpreting the Constitution. So, this statement is incorrect. First of all, the term unanimously should ring a bell. Any term that is absolute should definitely make you question the statement. Now, this ruling was MP Sharma versus Satish Chandra, and the other ruling was Khadak Singh versus the state of Uttar Pradesh. And in these, the right to privacy was not included as an integral part of Article 21, and the Supreme Court actually corrected this earlier interpretation. So this is inaccurate. The third statement says the Supreme Court held that the right to privacy shields the inner sphere of an individual from intrusion by both state and non-state actors. So again, this we have discussed. This right is available not only against the state but also against non-state actors like individuals and other private entities like your companies. This particular statement where the law is applicable not only against the state, or the right is available not only against the state but also against other individuals, is called the horizontal application of rights. Concept of horizontal application of rights. So this statement is accurate. How many of these statements given above are correct? Only 2. Here again we have option B as the correct answer. This is the explanation. Kindly pause the video and go through. Question 4. Consider the following statements regarding preventive detention. Now, when we talk about preventive detention, we are immediately taking protection against arrest and detention in certain cases. And here we are talking about preventive detention, meaning there must be another kind of detention. There are 2 kinds of detention. Punitive, as the word suggests, punishing someone for an offense, and then there is preventive detention. In preventive detention, a person is arrested without any trial in order to forbid or prevent that person from committing a crime. All right. So that person has not committed a crime yet, but the authorities want to prevent that crime from being committed, and hence preventive detention comes into action. Over here, punitive, again, punishment. So it comes after a crime has been committed. Now, no preventive detention law existed in India before independence. This statement is incorrect. Whenever, like I told you, the absolute words all, absolute, no, none, please think and question the statement. Is it possible that there was no preventive detention law before independence? Absolutely not. This is not new to India. So there were the Defense of India Act of 1939, for example, which was a preventive detention act, or the Bengal State Prisoners Regulation, which was also a preventive detention act. So this statement is inaccurate. The second statement says every detained person must be produced before the nearest magistrate within 48 hours of arrest. Now here, this statement, first of all, is referring to punitive detention, and the rules are different. The protections afforded are different to a person who has been arrested under punitive detention and to a person who has been arrested under or detained under preventive detention. So here, when we are talking about an ordinary arrest under ordinary law, which means not preventive detention, there are certain protections that are accorded to the arrested person. For example, that person has the right to be informed about the grounds of that person's arrests. So what are the reasons that that person was arrested? Under this ordinary detention, that person should be told. Again, that person has the right to consult a legal practitioner of his choice to defend that person. So that is also permitted. Then that person must be produced in front of the nearest magistrate within 24 hours. And unless there is further direction from the magistrate, that person will have to be released. So these are some of the protections that are given to a person under ordinary arrests. The same are not provided to a person who has been arrested or detained under preventive detention. However, they have a protection that they cannot be detained for more than months unless an advisory board permits them to do so. All right. So this is what we have. Now, if we look at the statement, every detained person must be produced. No, not every detained person, because a detained person could also be detained under preventive detention, and to that person, these rights are not provided. Again, must be produced before the nearest within 48 hours, no, within 24 hours if under ordinary arrest, ordinary detention. So this statement is also incorrect. So which of the statements given above are correct? Neither 1 nor 2, and therefore have option B as the correct answer. And here you can pause the video and see that there are certain safeguards that are available under ordinary law, whereas under preventive detention we have this safeguard that the person cannot be detained for more than 3 months unless an advisory board consisting of high court judges finds sufficient cause for continued detention. So here we have option B, the correct answer. Question 5, which Supreme Court judgment held that an indefinite suspension of internet services is unconstitutional and that shutdown orders must satisfy tests of necessity and proportionality. Now, when we are talking about indefinite suspension, this is the problematic issue over here. So, the Supreme Court in the Anuradha Bhasin versus Union of India actually discussed that any suspension of internet services, first of all, violates Article 19, right to freedom and freedom of speech and expression. First of all, it is in conflict with that, so it must be avoided. shutdown of internet services must be avoided. And this is in reference to the internet shutdown that took place in J&K on 4th August 2019, right around the time of the abrogation of Article 370. So here, first of all, there should be no indefinite suspension. Second of all, any such suspension must pass the test of necessity and proportionality. Test of necessity meaning, is this shutdown really necessary? Is it really required? And proportionality means, is it in line with the, or is it for the time duration for which it is required, or are we exceeding it? Is it in excess of the requirement? So these two tests ought to be considered by the government. And again, the government not only has to satisfy these, but has to inform that they are going to be going ahead with such a shutdown order. And this was decided in the Anuradha Bhasin case, and therefore option B is the correct answer. So here, while the court itself did not order the restoration of internet services, so the court did not say, oh, you restore the internet services, but it did direct the government to review all shutdown orders using the tests laid down in the judgment. What were the tests? The tests of necessity and proportionality, and to revoke those that were unnecessary or lacked a definite time limit. Indefiniteness is what was causing a problem, and freedom of expression is, or on the internet, is a fundamental right. So again, while the government does possess the power to impose a complete internet shutdown, any such order must be publicly notified, and very importantly, it remains subject to. Next question. Consider the following statements regarding the essential religious practices. Now, what is essential religious practices for the RP doctrine? Now, this is a doctrine that was again established, or let's say evolved by the Supreme Court, and it is defined according to this doctrine. Essential religious practices are those the absence of which will alter the fundamental character of the religion. So this is what is defined as essential religious practice. Now, when we talk about right to freedom of religion, we are talking about Articles 25 to Articles 28, and the state indeed protects freedom of its citizens. However, only those freedoms are protected which are essential religious practices. Otherwise, not. So the state is basically allowed to do or reform the religion, let's say either for social reform or to maintain public order. But the state cannot really tamper with essential religious practices. That is the whole idea. Now, statement 1 says, under the doctrine, only those practices that are integral to the religion as determined from its own texts and tenets are protected under Articles 25 and 26. This is absolutely correct. How is it determined whether a practice is essential to the religion? It is determined by the courts from the text and tenets of that religion. So this statement is accurate. The second statement says the legislature is not permitted to reform or regulate a religion in a manner that it destroys its essential identity or eliminates its essential practices. Again, this is correct. I told you the legislature can actually, or the state can actually, reform a religion on the grounds of, let's say, public order or even for social reform, but not so much as to destroy its essential practices. The third statement says the Bombay High Court has held that the use of loudspeakers does not qualify as essential religious practice under Article 25. This is also absolutely correct. The Bombay High Court had indeed held that loudspeakers do not constitute a part of the essential religious practices, and therefore all of the three statements are correct, and we have option C as the correct answer. Now, if we look at explanation, we see here that in the Sardar Sayyidna Tahir Saifuddin Sahib versus State of Bombay case of 1962, the Supreme Court held that any essential religious practice must be identified from the text and tenets of that religion. Again, in the Commissioner of Police versus Acharya Jagdish Sharananand Avadhut 2004 case, the Supreme Court clarified that the test for determining essential practice is that the practice is essential if its absence alters the fundamental character of the religion itself. So this is that case. All right. Again, in Shaira Bano, very famous, very recent case versus Union of India of 2017, the Supreme Court ruled that triple talaq was not an essential Islamic practice. And similarly, most recently, the Bombay High Court also upheld that the use of loudspeakers does not constitute an essential religious practice. Question 7, religious instruction is completely prohibited in which type of educational institution under Article 28? Now, Article 28 actually kind of divides educational institutions into 4 categories. And again, this has to do with the freedom of religion. So we are talking about state-recognized institutions, state-aided institutions administered by the state under a trust, and institutional wholly patch, and institutions wholly maintained by the state. Now we are talking about state-recognized. Now here, these are institutions which are recognized by the state, but the state is not maintaining them or aiding them. So here, the religious instruction is permitted. It is permitted. Again, in state-aided institutions, it is permitted, but on a voluntary, meaning that the pupils, students cannot be forced to, or it cannot be mandated that the pupils do attend such religious instructions that are provided in state-aided institutions. And in case that they have to participate in that religious instruction, they have to consent from their guardian. All right. Now, when we are talking about institutions administered by the state under a trust, so here the thing is that even though the institution is being administered by the state, it is under a trust. And if that trust is a religious trust, then here again is allowed. This instruction is very much permitted. But institutions which are wholly maintained by the state, and we know that India is secular, so of course there is going to be no religious instruction, because if we are secular and we treat all religions equally, which religious instruction are you going to impart, right? So we have option B, the correct answer. And here have the explanation. Kindly pause the video and take a look at it. Question 8. Consider the following statements regarding the writ of habeas corpus. Now, before we consider any statement, let's just understand what habeas corpus is. Habeas corpus literally means to produce body of. And this is a writ under Article 32 and Article 26 with the Supreme Court and the High Courts respectively. Now, the first statement says the writ of habeas corpus issued even against private individuals who illegally detain a person. So, normally when we talk about habeas corpus, we are talking about individuals who are detained and ought to be produced before the nearest magistrate within 24 hours. That is where the writ of habeas corpus is issued. However, not only against the state, against private individuals who are illegally detaining a person. All right. So this statement is accurate. The second statement says habeas corpus can be issued even when the detention is ordered by a competent court or is lawful. No, if the detention order has been issued by a competent court and it is not illegal, it is pretty much legal, then of course you cannot issue the writ. Then there is no purpose of the writ because it is lawful, the detention order is lawful, legal, as well as done by a competent court. So this here is, so here question asks us which of the above are not correct, and therefore the second statement is not correct, and we have option as the correct answer, which is 2 only. Kindly pause the video and go through the explanation. Question 9, consider the following, and 6 actions have been given. And the question asks you, mandamus cannot be issued in the above situation. Now, what is mandamus? Again, mandamus is literally translated to the command, and it is a writ under Article 32 and 226 available with the Supreme Court and the High Court respectively. Now, what does mandamus mean? It means the command. Who commands? Basically, the courts can command. Whom? They can command lower courts and tribunals. About what? They can command lower courts to follow the duty that has been bestowed unto them if they are not doing their duty. Meaning, if there is inaction, then the writ of mandamus is issued in case of inaction. Why or when? So, in case the duty is mandatory. So, if a lower court is expected to do a duty and that duty is mandated, it is mandatory, and yet there is inaction on the part of the lower courts or tribunals, then of course this writ can be issued. And this can be issued only in public matters, not private party, not contracts. All right. So again, let's consider the following and see how many of the above cannot have mandamus issued against them. The first one says against a private individual or a private body. No, it cannot be. It can only be done against the state. To enforce departmental instruction without statutory force. Now, of course, it has to be something that is legal, something that is mandatory and legally binding, both. So, if there is no statutory force, there is no legal force behind it, then the writ of mandamus cannot be issued. When the duty involved is discretionary and not mandatory, we just read that the duty involved ought to be mandatory and not discretionary. Here, in case of a discretionary duty, you cannot really, or courts cannot really command lower courts to do something. To enforce a contractual obligation, no, again, this becomes a private matter and this cannot be inviting a mandamus. Against the President of India or a state governor, we have read about Article 361 and the immunity that is provided to the President of India as well as the governors of the states, and therefore, of course, mandamus cannot be issued against them. Finally, against the Chief Justice of a High Court acting in judicial capacity, absolutely not, cannot issue the writ of mandamus against the Chief Justice of a High Court, particularly in their judicial capacity. So, against how many of these, or in which of the above situations can mandamus not be issued? In all of the above, all of the 6. Therefore, option answer. Here we have the explanation. Mandamus cannot be issued against all of these that was given. So, the writ may be issued against a public body, a corporation, inferior court, tribunal or government for the same purpose. Last question, question 10. Consider the following statements regarding the writs. I have just studied about a couple of writs. And here, the first statement says, while prohibition is issued to prevent a lower court or tribunal from exceeding its jurisdiction before a final order is passed, certiorari is issued after the final order to quash it. So, the writ of prohibition simply means to prevent or to prohibit. As the name suggests, what must be the purpose of this writ? To prevent something from happening or to prohibit something from happening. What could that be? It actually is to prevent a lower court or tribunal from exceeding its jurisdiction. All right, before a final order is passed. So that final order is actually, or that court or tribunal is actually prohibited from passing a final order. Now, when we read about mandamus, mandamus was actually a writ issued against inaction, whereas prohibition is a writ issued against action. So to prevent that action happening, to prevent a lower court or a tribunal from exceeding their jurisdiction to pass a final order, the writ of prohibition is passed or issued. Here, we are also talking about certiorari. Certiorari is actually to be informed or be certified. What does it do? It basically quashes an order, an illegal order, after it is passed. All right. So if again the authority that passed the order was not qualified to pass that order or exceeded its jurisdiction, all right, then we pass the order, or the courts pass the order of certiorari, meaning you stop it or quash it. It has already been passed. So when we talk about prohibition, we are actually talking about prevention, preventing an order from being passed, whereas when we are talking about certiorari, we are talking about correction in the sense of correcting by quashing an order that was passed. So this statement is correct. The second statement says both prohibition and certiorari can be issued not only against judicial and quasi-judicial bodies, but also against administrative authority. Now, both these orders can be only issued against judicial and quasi-judicial bodies, because we are talking about passing orders here, and that is usually the suit of judicial and quasi-judicial bodies. So no, they cannot be issued against administrative authorities, but only against judicial and quasi-judicial bodies. So again, this statement is incorrect, and we have one statement correct. Therefore, option A is the correct answer. Here is the explanation for you. Please pause the video and take a look at it. Now here I have brought to you a practice question. Kindly read the question carefully and do send me your answers in the comment section. If you liked today's session and if you found it fruitful and useful, kindly hit the like, share and subscribe button, and thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.